So, ACN work program 2023-26 envisage regional policy dialogue as a part of its steering group annual meetings, aimed to promoting successful anti-corruption reforms and experience sharing on the areas covered by work program, including, of course, business integrity. And regular regional anti-corruption trend reports are foreseen as an evidentiary basis for these sessions and using key performance indicators and standard framework for analyzing anti-corruption trends within ACN countries. The pilot anti-corruption trends report for Eastern Europe and Central Asia, which was released last week, focuses on anti-corruption policy and business integrity, showcasing trends, achievements, challenges, and of course best practices in the region. This report is in the back of the room, if you haven't it yet. And the regional dialogue session at the last year steering meetings highlighted the preliminary findings of this study of anti-corruption session, and today we will discuss and devote this session for the key issues within the area of business integrity. And I would like to give the floor for Erkla Urshadze, who will moderate this session. Thank you.
Thank you, Mr. Chairman. Thank you, and again, welcome to everyone, those in the room and those joining us online. The Business Integrity chapter of the Regional Trends Report offers an overview of legal framework and of practices in 21 ACN countries based on KPIs divided into 5 policy areas. And I am now trying to bring up. Okay, so you will see the list of these 5 policy areas that are covered in this business integrity chapter. As most of you are probably aware, ACN has a dedicated work stream on business integrity, and we do a number of things as part of that work stream. And one of the key elements of that work stream is what we call diagnostics. It's our efforts to gauge where countries stand on business integrity, what challenges they are facing, and what solutions they are coming up with that have proved effective in practice and can consequently be shared with other countries. And so in that context, the Regional Trends study was a useful exercise for us, again in the context of our work on business integrity in a number of ways. First, it provided a snapshot of the state of affairs across these 21 countries that were covered in the study, so we can kind of zoom out and look where the region and different countries that are part of the region stand in these 5 policy areas. That's one way that it was definitely useful. But also the study and the information that we gathered from the countries as part of this study made it possible for us to identify promising emerging practices in individual countries. And so what we wanted to do today during this regional dialogue session is to spotlight some of these interesting practices, some of these good practices, best practices, because it is one of ACN's core missions to promote experience sharing and learning across the region. So we will devote the next 40 minutes of the session to bringing you these examples, and we're lucky to have with us the representatives of the countries that were highlighted in this report due to some of the interesting examples they offer of what we believe are successful and effective policies on business integrity. The OECD 2021 recommendation, which kind of supplements and reinforces the OECD Anti-Bribery Convention, highlights the need for companies to develop and adopt effective internal controls, ethics, and anti-corruption compliance programs. And in the Regional Trends Report, we have KPI 8, one of the key performance indicators, which looks at whether governments in the countries have assisted companies in developing such internal controls and compliance programs. And in this context, one country practice that drew our attention was Lithuania, where the Lithuanian Special Investigation Service has developed guidelines for creating anti-corruption environment for business. And so we have Mr. Domantas Lukauskas here, who is the head of the Corruption Risk Division at the Special Investigation Service. And he has kindly agreed to join us today and share the experience. So Domantas, I would like to ask you to talk to us about briefly about the experience of developing these guidelines. First, of course, in terms of the scope of the issues that they cover, but also your experience in terms of engaging the companies in the process of developing and adopting these guidelines, how strong has been the interest from companies, what steps you have taken to generate or enhance this interest, and then whether there has been any kind of feedback process from the companies that have adopted these guidelines, whether they have come back to you for consultation. And also, maybe you could also mention how this is linked to the broader initiative of STT, which is the Integrity Academy that we are aware of. We have discussed this during our previous meetings. So the floor is yours.
Thank you very much. Good afternoon, ladies and gentlemen, dear colleagues. It is an honor for me to be here today and to share Lithuania's practice towards corruption prevention in private sector. So without further ado, in 2022, a new version of the law on the prevention of corruption of the Republic of Lithuania was adopted, Article 22, which states that the participation of business entities in creating corruption-resistant environment is based on the voluntariness of these entities and cooperation between the public and private sectors. The law does not establish any mandatory provisions for private sector entities, neither did older versions of law on the prevention of corruption. However, we understand that transparent, honest, and open business practices are one of the key elements of good business reputation, both in state-owned enterprises and private sector companies. Sociological and scientific studies show that businesses that implement anti-corruption measures in their activities become more competitive than other market players in long term, protect and even improve their reputation, are able to attract more investment, increase income, establish long-term relationships with reliable business partners, and avoid possible negative legal consequences. It is important to recognize that corruption is a complex phenomenon with economic, social, political, and cultural aspects that cannot be easily eliminated. Therefore, we understood the importance of private business involvement in corruption prevention activities. The legal basis for the guidelines was Lithuania's former National Agenda on Corruption Prevention for 2015-2025, in which we identified the issues related to the spread of corruption in the private sector, identifying risks in areas of media, sports, education and science, legal services, personal health care services, and pharmacy. The agenda also indicated the need for cooperation between the public and private sectors, stating that joint efforts to prevent corruption in the public and private sectors by coordinating actions would strengthen the internal market economy, and even national security. Therefore, it included the task of developing anti-corruption education in the public and private sectors by encouraging them to contribute to the development and implementation of educational prevention measures, and to conduct targeted education in the most risky areas in the public and private sectors. In order to implement these tasks, the Agenda's action plan included a measure to prepare a guide for creation and implementation of anti-corruption environment in the public and private sectors. As a result, in 2017, the first anti-corruption guide for business was introduced. Further on, importance of private sector's contribution and participation in corruption prevention remained, and the same as understanding that corruption works in both directions. Therefore, new National Agenda on Corruption Prevention 2022-2033 also paid great attention to public-private sector cooperation in corruption prevention. As a result, in 2023, the Anti-Corruption Guide for Business was updated and entitled as Guidelines for Creating an Anti-Corruption Environment for Business. The guidelines have been developed and the measures described based on United Nations Convention Against Corruption, OECD Convention on Combating Bribery of Foreign Public Officials in International Business Transactions, National Security Strategy, Law on the Prevention of Corruption, Law on the Protection of Whistleblowers, law and lobbying activities, and national anti-corruption agenda. In addition, the draft guidelines were coordinated with private sector entities to ensure that the final result would maximally meet the needs of the private sector. The new version of the guidelines differs from the old ones in several aspects. First of all, in terms of volume, 116 pages versus 23 pages. We wanted to simplify the guidelines so that the methodological material would be easy to read, understand, and quickly find what you need, and convenient links would provide access to more detailed, relevant information. Therefore, we also changed the structure itself. When preparing the guidelines, extensive theoretical part defining corruption, its forms, possible consequences, and a very detailed description of corruption prevention measures was abandoned. A decision was made to describe the measures briefly, listing the main aspects, providing references to related legal acts, other methodological material. A particularly important aspect is that the guidelines provide references not only to methodological material, but also to examples of good private sector practice, to the pages of business entity that apply relevant prevention measures. The guidelines for creating an anti-corruption environment for business is practical and methodical tool for Lithuanian private sector entities seeking to operate in a transparent and responsible manner. Its aims you can see in the slide. And the guidelines are indicative in nature and have been designed to be applied by private sector entities of all sizes and in different fields of activity, hoping that this will lead to the best results in creating an anti-corruption business environment. The content of the guidelines consists of the following parts: international and national legislation, which specifies both national and international legal regulation with references to it, business associations and initiatives uniting transparent business, which specifies private organizations and associations operating in Lithuania that encourages businesses to act in a transparent and responsible manner and share best practices to follow good examples. Key principles that should guide business in creating an anti-corruption environment. The principles themselves are specified and the reference is made to ISO standard 37001. Also, measures to ensure transparency in business. The most commonly used and most significant measures for creating a corruption-resistant environment are presented, and you can also see them in a slide. And lastly, transparency and public accountability. Specifies what information organizations should make public in order to promote integrity, improve its reputation, attract investors and talents. The new guidelines for business were presented in May 2023 during the Integrity Academy event, and the Integrity Academy is a place for exchanging good anti-corruption practices, where transparency standards experts with the most experience and the highest competence share their experience and advice on how to create a corruption-resistant environment. Initiative was established on December 2020, and its main areas of activity are good practices, sharing events and mentoring. Initially, the initiative was intended for public sector organizations, but from 2022, private companies striving for transparent business can join it. The organizers of Integrity Academy is Special Investigation Service of the Republic of Lithuania. The exchange of good practices of the Integrity Academy is initiated by President of the Republic of Lithuania. During the aforementioned event, with the participation of the Transparency International Lithuania chapter and representatives of large businesses, the new guidelines were presented along with sharing of business experience in achieving transparency. We also mentioned the guidelines during other events held with private businesses, emphasizing the importance of risk management. The guidelines are available both in Lithuanian and English on the STT website. Since these are guidelines, our service do not specifically collect information about how, in what way, or from business follow the guidelines, but from time to time we also receive questions from private sector entities or other associations regarding the application of the measures mentioned in the guidelines, which indicates that business are aware of the guidelines and apply them. So in conclusion, critics may say that this is not the best way to implement transparency standard in the private sector because the regulation do not establish mandatory measures, and at the same time there is no specialized supervision of their application. However, I could single out several positive aspects and counter-arguments for such opinion. First of all, this is an easy to understand and use methodological material accessible to business of any size. STT also organizes both separate events and provides direct consultations on individual issues of applying corruption prevention measures, which is especially relevant for small and medium-sized businesses that do not have developed risk management system, human resources, or knowledge, but want to operate transparently. Secondly, declarative and formal application of measures is somehow avoided. When a business entity realizes the direct and indirect benefit of transparency and risk management, measures are applied without direct pressure and therefore effectively. And last, voluntary involvement of the private sector. The fact that other private sector entities see examples in the guidelines from the practice of their business partners or learn about the guidelines from them and not from law enforcement institutions significantly increases their value. And real business examples only further encourage the pursuit of transparency. So, as I mentioned, the guidelines are also publicly available in English, and if you have any questions, you can approach me after the event or email me. Feel free to email me. Thank you.
Thank you, Domantas, for this intervention, which undoubtedly provided very interesting insight as to what public anti-corruption authorities can do to help companies develop their internal safeguards against corruption. Staying on the subject of internal controls and going back to the OECD anti-bribery recommendation, in line with this recommendation, countries can incentivize companies to adopt internal controls by a number of things. For example, they can consider the existence of internal controls and compliance programs in their decision to award public advantages to companies. They can also consider the existence of internal controls and other compliance measures as a mitigating factor in corruption cases against legal entities. Now, this type of incentive also creates, obviously, the need to ensure that this adoption of anti-corruption controls by companies is not formalistic in nature, and so that these incentives do not essentially turn into a loophole that can be abused by dishonest officials or dishonest companies. And so there is a need for some sort of monitoring and verification of the compliance measures implemented by companies. Now, in the ACN region, unfortunately for now, it remains rather uncommon in the ACN region for public authorities to engage in the monitoring of compliance programs of companies. But ACN, being a global outreach program of the Working Group on Bribery, and also being nested in the OECD Anti-Corruption Division, we have, of course, the advantage of having access to the larger pool of experience of WGB member countries. And so we are lucky today to have Ms. Claire Dubois-Lidon, who is the Senior International Affairs Officer at the French Anti-Corruption Agency. In France, the law requires large companies to implement internal compliance measures, and the French Anti-Corruption Agency, AFA, has the mandate to monitor how companies comply with this requirement. And so, Claire, first of all, thank you for being with us today. And I would like to ask you to tell us more about the AFA's compliance audits, about the process, what can trigger an audit, and what does the audit process involve. And also, perhaps you could tell us about how the results of the audits can feed into the decisions by the relevant authorities, whether or not to consider compliance measures implemented by a particular company, a mitigating circumstance in a corruption case against it. The floor is yours.
Thank you very much, Mr. Moderator. Good afternoon, ladies and gentlemen. It's a pleasure and an honor to be here today and to share some elements from the French anti-corruption system. But first, maybe let me share a couple elements on the French Anti-Corruption Agency before diving into the business integrity part of my presentation. So the agency, which I will call AFA, was created by a law of 2016 on the transparency, fight against corruption, and modernization of public life, which is called the Sapin law. AFA is a service with national competence, so spanning over the full French territory, and headed by two authorities, the Ministry of Justice and the Ministry of Economy and Finance. The agency is headed by a high-level member of the judiciary for a term of 6 years, which is not renewable, and the status of this head of agency allows us to have the perfect independence in the handling of our mission and mandate. AFA's main mission is to assist both from an advisory perspective but also from a control one, the competent authorities and individuals in preventing and detecting corruption. So it's not an investigative service, and we are focusing only on 6 offenses, which are corruption, influence peddling, embezzlement, illicit conflict of interest, misappropriation of public funds, and favoritism. The Sapin law also recognizes AFA as the competent authority in France to receive alerts from whistleblowers. And finally, last word on our organization. Our advisory and control missions span both over private companies but also the public sector, for example, ministries and local governments. But of course, for the sake of this presentation, I will focus on the private sector only. So first point today, what can trigger an audit from AFA within a private company, and how does it work? Regarding companies, AFA's missions of advisory and control can be exercised as part of several of its prerogatives. The decision to audit a company can be first taken and decided by the director himself, this is known as initiative controls because AFA has the initiative of the controls. And we have a minimum set of thresholds, whereas the company who are covered by these controls. It's only the biggest ones in France, so with a threshold of minimum 500 staff and a yearly turnover of 100 million euros. More or less, today in France, it's 2,000 companies. Second case where we can deploy a control of a private company, it's within the framework of compliance injection decisions decided by AFA's Sanction Commission. And these two first categories, initiative and execution controls, they aim to ensure the existence, the quality, and the effectiveness of anti-corruption measures. It's not only to have some controls and mechanisms in place, it's to really ensure they are implemented rightfully by the company. There are 8 of them that AFA controls, which are defined by law, so it's a legal requirement for companies to have them, and they are subject to AFA's control. The first one is an internal cartography of risk. We ask company, and the law requires company, to have done a mapping of all the risk from all the departments that can happen. This is, for example, the Human Resources Department, the Procurement Department, but also everything related to external partnerships or relationships. So first, cartography of risk. Second thing is a code of conduct. We establish by law that we need to find this code of conduct within the company, and any employee must abide by this code of conduct. Third element, the availability and enforcement of internal trainings on the prevention of corruption. It's not only something to have the training, but the company is responsible to have all staff regularly assessed on the knowledge of corruption prevention measures. Fourth element, third-party evaluation procedures. Because these big entities have most of the time a lot of subsidiaries or partners to conduct their commercial activities, we think and we believe it is the responsibility of the mother entity to make sure that their relationship with third party is assessed. Fifth element is the internal alert mechanism. So AFA controls that there is a way that internal whistleblowers can report alerts internally. This is not only that it exists, but we also control that this methodology, this way of reporting an alert is known by all staff. 6 elements that we control is internal and external accounting procedures. 7th is disciplinary sanctions. And 8th is the internal control and evaluation mechanism for the implementation of risk prevention measures. More or less said a bit more straightforwardly, it's to make sure that the risk mapping is backed up by a risk management approach, that when a risk occurs, the company knows how to mitigate it. The controls made by AFA can be covering these full 8 measures, or can be thematic. For example, they can focus on one of these elements, or one type of probity breach. We have corruption, traffic of interest, and so on. But they can also focus on a specific sector. So the head of the agency decides to prioritize one specific sector where the risks have been assessed to be the highest. For example, in 2024, the agency was extremely present and involved in the sports sector within the organization of the Paris Olympics, and we did a lot of work controlling both the companies that were supporting the organization of the games, but also the sports federation and the public sector with the town halls that were hosting the events. At the end of the controls, AFA provides the representatives with a report in which it makes observations regarding the quality of the anti-corruption system, and also, when it's needed, provides an action plan aimed at improving existing procedures. AFA can identify breaches or incomplete or ineffective implementation of the measures. When this happens, there are several ways to deal with this. The director of the agency may issue a warning only. Second case, the director can refer the matter to an administrative sanctions committee that is internal to AFA but independent, and this commission can impose administrative sanctions. Finally, when a major case of corruption is seen within the controls, there is an article in the law that allows AFA to transfer this alert to the investigative entities in France. And finally, the scheduling of initiatives control take into account the environment and risk of exposure. As I was telling you, we really focus on specific risk and sectors. For example, international activities which generate exposure to the risk of foreign public official corruption, sectors of activity and profession, geographic areas, and so on. Now my second point, which I think is important in a way of best practice sharing, and I will be very interested to follow up discussions on this, is a specific mechanism that was defined by the Sapin law, which we call the Public Interest Judicial Agreement. This is actually coming from inspiration from the United States and the United Kingdom, and it's a mechanism that can be only used for legal entities, so not private individuals which are members of a company. It's really the legal entity that we focus. When this legal entity is accused of corruption, influence peddling, or money laundering, there can be a public interest judicial agreement that is proposed to the company at the initiative of the public prosecutor. In France, for corruption cases, it's the National Financial Prosecutor's Office. So how does this work, this kind of bargaining or negotiation approach? There are several steps. First, in case of a breach in corruption found out in a company, there is an informal discussion between the prosecutor, the legal entity, their lawyer, and AFA. Second step, the prosecutor informs the victims of corruption and requests that they share an estimate of the financial prejudice. Third, there is a draft version of a convention, this public interest judicial agreement, that is sent by the prosecutor to the company. The company needs to accept it, and then it's transmitted to court and reviewed in a public validation hearing. After a retractation period, the press release that is public actually shares that a company has signed a public interest judicial agreement. Now, what is the advantage for the company? There is one huge advantage, and it is that public prosecution is extinguished. From now on, there is no conviction of the company possible, no entry in the criminal record. There is also no prohibition to participate on public contracts. But these advantages, the extinguishing of the prosecution, they come with some requirements from the side of the company. First, there may be a public interest fine, which can go up to 30% of the yearly turnover, so it's quite a significant amount. And there is also the capacity for the judge to act an implementation of a compliance program, so the company needs to abide by a compliance program to fill the gaps in the corruption under AFA's control for a maximum of 3 years. In the event of a failure, so if the public interest judicial agreement does not go until the end, sometimes it's because there is a failure in the negotiations, because the company just withdraws from the discussion or just fails to perform their requirements, the public action is resumed. So it's not because you have this mechanism in place that it always goes up until the end. And if it doesn't, you can still prosecute the company. Since 2017, 75 public interest judicial agreements have been conducted in France, including 25 for corruption and influence trafficking. Today, 16 of them are still monitored by AFA. If I can share some examples from maybe cases that you have heard about, in the financial sector, the bank Société Générale signed a public interest judicial agreement in 2018 with a 500 million fee and a collaboration with the US DOJ. And more recently, the Airbus plane company signed a public interest judicial agreement, resulting in a fee of 3.6 billion euros and a collaboration with the US and the UK. With these examples, I conclude my keynote. I was delighted to share some elements from our context, and AFA stands ready, of course, to discuss this further with you and to find potential areas of interest that on which we could cooperate. Thank you.
Thank you very much, Claire, for this very, very useful and interesting intervention. So that really it is one of the core missions of ACN to be a bridge between the ACN countries and countries outside the ACN, and of course, first and foremost, the WGB member countries. Of course, some ACN countries are now also OECD members and WGB members, but most ACN countries are not. And so it's the events like this, and generally ACN work is really an opportunity for us to bring this experience that the countries have accumulated in applying some of these standards. And so it was very interesting to hear how you're describing this, how these standards are implemented in France, the compliance as a mitigating factor in the non-trial resolutions, and then future compliance, subsequent compliance measures as part of the non-trial resolutions, and then the monitoring, of course, which is an essential component of this. So thank you very much, and we very much hope to remain engaged with AFA in our future work in the ACN region, in our learning and capacity building work. So thank you very much. One special area where governments have particularly high degree of responsibility with regards to business integrity is, of course, the operation of state-owned enterprises and all the standards concerning internal controls and compliance that are established by the relevant international instruments, including the OECD Anti-Bribery Recommendation and its second annex, apply equally to the state-owned enterprises, of course. And so, in this context, the Regional Trends Report highlights the example of Romania's Agency for Monitoring and Evaluating the Performance of Public Enterprises, AMEPIP, which was established in 2023 And so we would like to learn more about this emerging practice, and so we have invited Ms. Irina Zamfir, who is the senior advisor at this agency. And so, Irina, I would like to ask you to give us a short overview of the agency's mandate and its work to date, particularly in terms of monitoring the compliance of state-owned enterprises with the relevant legal framework in the field of integrity, as well as the monitoring of the application of corporate governance principles and selection of members of the SOE governing bodies.
Thank you. Distinguished delegates, ladies and gentlemen, it's a pleasure for me to be here and to present the current developments from Romania related to the implementation of integrity standards within the state-owned enterprises from our country. As Eric earlier mentioned, AMEPIP was established in 2023. It was the result of an extensive legislative reform in the field of corporate governance with the aim of aligning the regulatory framework from our country to the best international practices in the field. Therefore, AMEPIP was established at the center of the Romanian government as an entity with the role of coordinating the ownership function and to monitor the implementation of corporate governance practices and policies within all SOEs. We should mention that currently Romania's portfolio comprises approximately 1,400 countrywide SOEs. In relation to the integrity standards, AMEPI's mandate is that of monitoring the compliance with the legal framework on integrity, of the implementation of the integrity plans, and of the provisions of the National Anti-Corruption Strategy. As of the date AMEPI became operational, which was last year in March, the agency took significant steps towards the development of an integrated system for the implementation of integrity standards. I would refer here to the database created by AMEPIP containing the contact information of the compliance officers nominated by the SOEs. So the compliance officer plays a crucial role in implementing the integrity plans as management instruments used for the promotion of the organizational integrity within the SOE. The compliance officer actually represents the contact point between AMEPIP and the SOE, so he plays a crucial role in this respect. In order to clarify the type of tasks that should be performed by the compliance officers, AMEPIP, with the assistance from the Ministry of Justice from our country, drafted and approved in March of this year the Guide of the Compliance Officers, a tool which contains recommendations referring to their duties and the communication channels which should be established with AMEPIP. Also, I would mention that in order to monitor the compliance of the SOEs with the legal provisions on integrity, AMEPIP has developed and is currently in the process of implementing an online form with specific questions to be filled in by the SOEs. Just to give you an example, through this form, the SOEs are required to submit whether they assumed an agenda on organizational integrity, such being a legal requirement for all SOEs. Moreover, I would point out that AMEPIP has organized training sessions for the representatives of the SOEs aimed at clarifying the role and responsibilities of the compliance officers as well as the legal requirements on integrity. It is important to mention that just last month, so June 2025, roughly 200 SOEs representatives attended these sessions. As regards the selection of board members, AMEPIP has the ultimate responsibility to ensure that the process is done in transparency and competitivity, and in this scope, AMEPIP is not only part of the selection committee, but also endorses the final reports of the selection itself. thus making sure that the selection criteria of the candidates are based on merit, with a focus on removing the influence of the political factor from the overall process. The current legislation not only provides for improved selection criteria, but also includes criteria which could identify potential political affiliation. Also, the selection committee has the possibility to perform checks as to identify whether a candidate was declared incompatible or found in a situation of conflict of interest, therefore removing the respective candidate from the procedure itself, if such should be the case. Other important developments related to monitoring the corporate governance principles that should be mentioned are those related to the approval by law of the ownership policy, which not only establishes roles and the responsibilities, but also includes clear objectives and expectations for both SOEs and line ministries. Also, AMEPIP, since it became operational, developed a dashboard, which is an instrument used for the collection of financial and non-financial data, which is then used for monitoring the performance indicators. Lastly, I would point out that given that we are working with new pieces of legislation, the SOEs and the line ministries from our country have been confronted with challenges related to the implementation of the corporate governance legislation, and here MEPIP has played a significant role in advising on best practices. Thank you.
Thank you very much, Irina. The dedicated agencies responsible for monitoring the operation of state-owned enterprises and application of good governance principles and integrity principles in the operations of state-owned enterprises are not yet common across the ACN region. So, again, Romania's experience and example is very interesting, and I'm sure that the participants here, both present in the room and those online, will take note, and this is something that we would like to keep an eye on and keep highlighting in our future work on this subject. If I may use a couple of slides at this point. So as you will see, these are the KPIs from the original trends report, looking at how the appointments process in the state-owned enterprises in terms of selection of board members, selection of chief executive officers, whether it complies with the relevant standards, and we will see that there is still mostly only a minority of the 21 countries were found compliant with the relevant standards. So there is clearly a lot of work to be done there. Another area that we covered in this study was the disclosure of beneficial ownership information, which is, of course, a very important element in ensuring transparency and consequently accountability and integrity in business operations. And as you can see from the slide, on the one hand, majority of the countries that we covered have put in place systems for the disclosure of beneficial ownership information by the companies at the time of their registration. But then, as you can see from KPI 4, actually only a small minority of countries have so far managed to establish appropriate procedures for the verification of this information, and this is of course very important because disclosure without verification is not all that effective as a safeguard. And so, of course, we wanted to highlight an example where a country has in fact established such procedure and has applied in practice. And so, last but certainly not least, we have Ms. Tatiana Raicho-Georgieva, who is from the Bulgarian Commercial Register and the Register of Non-Profit Legal Entities, which is responsible for the verification of the beneficial ownership information which the companies present during their registration. So, Tatiana, I would like to ask you to tell us about this process, kind of talk us through the key stages and the elements of the verification process, and perhaps also give us a general overview of the experience in terms of the results achieved, the challenges you have encountered, and the lessons you have learned. I will also give you the... So the floor is yours.
Distinguished delegates, it's my utmost pleasure to have the opportunity to present to you the Bulgarian Beneficial Ownership Register, which is kept by the Registry Agency, an authority to the Ministry of Justice. My name is Tatiana Raicheva, and I'm a registration official at the Registry Agency. Holding this position, I tasked with entry to information in the Beneficial Ownership Register. As a member of European Union, the Republic of Bulgaria has introduced into the national legislation the requirements related to the fight against money laundering. The main law that regulates this measure is the Law of Measure Against Money Laundering, part of the norms transposed to the requirements of Directive 849 in 2050 and Directive 843 of 2018 of the European Parliament and the Council. In connection with the adopted completely new European legislation, in the field, a new regulation of the process in the fight against money laundering is forthcoming. According to the currently effective law, specified person and organizations entering into business relationship are obliged to carry out a check on these entities. Part of the check carried out including identifying the beneficial owner and taking appropriate action to verify his identification in a manner that gives sufficient ground of the person to assume that the beneficial owner has been established, including the application of appropriate measure to clarify the ownership structure and control of the customer. It is during the process of identifying the entities and their beneficial owners that checks are made in the commercial register and the register of non-profit legal entities and the boosted register. Our bioregister is not standalone. It is organized in the integral part of 3 registers also kept by the registry agency. The commercial register in which the trades such as companies are registered. The non-profit legal entities register where association and foundation are entered. The boosted register in which we register entities that are not subject to registration in the above mentioned 2 registers and arrangements that have not legal personality, as well as foreign entities that carry out economic activity in Bulgaria. The register contains 2 types of information. General information part, in which is entitled that so-called general information about the entity of legal arrangement, its name, address, legal representatives, partners, and case providing but law. Beneficial ownership part, where the beneficial ownership information is held. The Beneficial Ownership Register was launched on 1st February 2019, and we have already had a 6 years experience with its operation. Under the Bulgarian legislation, legal entities and other legal arrangements established on the territory of the Republic of Bulgaria and national person, legal entities and other legal arrangements which of trusts are obliged to have and maintain themselves accurate, adequate and up-to-date information about their beneficial ownership and to provide into the cases determined by law, including to submit it to be the beneficial ownership register in the 7-day term following the occurrence of the circumstances. Thus, within 7 days after the initial registration in the Representatives Register, Commercial Register, No-Profit Legal Entities Register or Bullstat Register, the entities or arrangements are obliged to submit their beneficial ownership information. The obligations also arise in case of the change in the beneficial ownership, wherein the 7-day term is applicable as well in case a failure of the entities of or arrangement is fulfill this obligation. Administrative panel may apply. These measures are imposed by the registry agency and the pecuniary fines. The bioregister entires the beneficial ownership information upon a notarized declaration submitted by the entity or arrangement accompanied by supportive documents. The rule of the latter is to prove that the dates about the beneficial ownership contained in the declaration. It's important to highlight that when we enter the beneficial ownership information in the bioregister, we do not rely only on the declaration, but we also check it against the supportive documents. The verification that it's carried out is solely based on the documents attached to the application. What information entered in the bioregister? Information about the beneficial owners, who are always national persons: the name, citizenship, the personal identification number, the date of birth, the country of residence if it's different for the Republic of Bulgaria or from the country of citizenship, nature and extent of beneficial interest held, the date on the legal entities or other legal arrangements through which control is directly or indirectly exercised over the legal entities registered in the Bulgarian register, so-called ownership chains, the date on the national contact person permanently residing in the territory of the Republic of Bulgaria in the cases where the legal representative is not a permanent resident. The obligation to submit beneficial ownership information for the registration to bioregistration arises from legal entities and the other legal arrangement established on the territory of Republic of Bulgaria, foreign or legal entities and other foreign or legal arrangements subject to registration in the Bullstat Register. It is to be noted that several exceptions to this rule exist. They are linked to cases in which the information for the beneficial owners is already contained in the registers, in their general information part. In the first place, the sole traders are exempt from the obligation to submit beneficial ownership information to the bioregister. The sole trader is a national person that carries out a commercial activity on their own without forming a legal entity. In this case, the sole trader or the beneficial owner conside because there are not other persons involved. The next exception for the legal entities whose beneficial owners are entered in the registers as partners or sole owners of the share capital of entity. That applies to case where the beneficial owner or owners coincide with the partners or sole owner which were entered on the file of entity in the register. In this case, the partners or the sole owners must be national persons. The exemption is also applicable to legal entities which partners or sole owners are legal persons, provided that the letter of entity in the Bulgarian register and the names of the ultimate beneficial owner, who are national persons, are entities of the files and partners sole owner in the register. That applies to ownership chains involving more than one legal entity, on condition that all of them entitled in Bulgaria register and that the ultimate beneficial owner, national person, can be traced for their files. Access to the bioregister. The register is public, internet-based, providing free of the chart immediate access from any point of world with internet connection. The information is available to anyone, the general public, the competent authorities, and the obliged persons such as banks, other financial institutions, insurance, and which conduct a due diligence check. The information contained in the bioregister is a machine-readable format. The information contained in the register of beneficial owners must be true, accurate, and up-to-date. What the amendment to the Anti-Money Laundering Measure Act of 16 July 2024, a new provision was introduced to Art 63A of the Anti-Money Laundering Act, which provides for the regulatory regulation of the so-called procedure for registering discrepancies. Persons who are obliged to conduct inspection and the administrative bodies, the Financial Intelligence Directorate of the State Agency of National Security, the supervision authorities, the Ministry of Interior, the National Revenue Agency, and the administration competent to exercise general control over persons upon establishing a discrepancy between enter circumstances, submit a notification to the commercial register and the register of non-profit legal entities, which is supported by evidence. Upon entering such a notification of discrepancy, the register automatically notifies the entry with the request to declare the change in the circumstances of its beneficial owners. In case it fails to submit an application for updating the information about its beneficial owners, the entity is punished with a fine. With the introduction of this procedure in the order to avoid entering a notification of non-compliance, which may be lead to negative consequences for the business status of the entities, an increase in the entire circumstances reading the beneficial owners representatively their updating is observed. The new European legislation provides for the removal of exception from the obligation to declare circumstances reading the beneficial owners. All entities operating in the territory of Republic of Bulgaria and registered in the commercial register and the register of non-profit legal entities and the boosted register will have an obligation to declare circumstances reading their beneficial owners. For Bulgaria, the norms of European legislation are to be noticed into the national legislation. Thank you.
Thank you very much, Tatiana. As I mentioned when I was introducing your intervention, it is really a challenge for many countries to move from kind of a formal requirement of disclosure to actual verification of this information. So this is a subject that we have highlighted and intend to highlight in future in our work, and to the extent that we can also provide the countries with advice on this, with learning opportunities, and also to promote exchange between the countries on the subject. Now I would like to open the floor for questions and for discussion. As Mr. Chair mentioned at the beginning, we have a mix, so we're here in the room, and we also have colleagues following us online, and this is a public event. So those joining online can also ask questions, and thanks to the kind help from my colleagues, I'm receiving the questions also, online questions on my phone, so I will try to be fair and to mix a little bit of both. So first I would like to ask those in the room if anyone has a question or comment, and I can see that Adam from EBRD would like to take floor, please.
Thank you. My name is Adam Lewis from the Compliance Department at EBRD. First of all, thanks very much to the speakers for the very interesting presentations. It's great to hear what is going on in the business integrity space in different parts of the world. I have a question for Mr. Lukauskas on your guidelines for companies in Lithuania, because something that we hear a lot, or what I hear a lot as a compliance officer, is from small businesses who are operating in environments where none of their peers are implementing business integrity controls. And of course we try to make the argument that it's better for you in the long run to institute compliance programs. It will be good for your business, but you know, it may not even be that they face particularly high risks. They may not have necessarily got into trouble in any sense, you know, on business integrity or compliance, anti-corruption related matters, but we still want to kind of help them improve. But they say, well, look, you know, it's going to make us uncompetitive because no one else is doing it. And I guess my question to you is, how do you incentivize businesses, the private sector in Lithuania to follow the guidance? I mean, or maybe there are kind of disincentives, you know, they fear there might be prosecution if they don't institute best practices in this area. So that would be a question to you.
Yeah, thank you for the question. I think we don't try to scare them of prosecution. Mostly we try to involve their partners, other private sector entities that applies in integrity standards, has measures that works, and when they hear from their colleagues from private sector that saying it is good, it's good for our business, it is good for our income, and they're not hearing from the law enforcement institution because they can't think, they always want to know that we had a bunch of measures, but when they hear from their own sector entities, I think this is what encourages them. As I said, we don't collect specifically information about measures applied, but from time to time we hear that they have questions and they follow their good examples of their colleagues, from their colleagues.
Thank you, Domantas, and thank you, Adam, for this interesting question. I see that Greco wants to take floor.
Thank you, Chair. I'm David Dolidze. I serve as a Senior Legal Advisor on Greco in the Council of Europe. I have a question to Ms. Zamfir. Before I ask it, I must explain myself a bit. Greco just launched the 6th evaluation round. It focuses on promoting integrity and preventing corruption at the subnational level. For the moment, it's too early to share any findings or feedback, but we are looking at some of the risk areas at the subnational level, local authorities, and some of those areas might be public procurement and municipally owned enterprises. And my question to Ms. Zamfir is this: does your agency also control municipally owned enterprises or others which are at the subnational level? And if it doesn't, have you come across bodies at the subnational level which are doing work that is similar to yours but at their own level? Thank you.
So AMEPIP controls or coordinates the activity related to corporate governance of all the SOEs, both local and central. And to date, we do not have information to share on the question just received.
Thank you. Moldova.
Thank you very much. First of all, I would like to thank the speakers for the very informative presentations. And I have a question for the AFA representative. My question is, does AFA or another authority keep statistics on the number of internal whistleblowing reports in the private sector? And if yes, how often the entities have to report? And if you know, what are the most frequent breaches reported? Thank you.
Thank you very much for this question. And yes, we keep track of statistical data related to corruption. I haven't mentioned it, but internally we have what we call an observatory for corruption offences, which is kind of a research center in a way that collates all the judicial cases on corruption and publishes a report annually. So we have the number of corruption cases, number of people prosecuted, and so on. When it comes to whistleblowers, we of course track the number of alerts. To give you an example, it went exponentially from a little bit more than 100 3 years ago to today more than 1,000 in the past 8 months this year. However, I should say that of course there is a huge work of triage of these alerts, because not 100% of them are actually accurate or report on actual facts. Roughly 50% of them we can proceed. And maybe the last element as answer to your question is that we actually receive, in terms of alerts, I would say that 3/4 are from the private sector and 1/4 from the public sector. The reason is that because we have these stringent requirements set by law in the private sector, all the mechanisms to report on the alerts are a bit more strengthened on the private side.
Thank you.
Thank you. I would like here to introduce one question that we received online, and I don't know if any. I don't think it was specifically addressed to any country. Maybe it was. So I will open the floor to any country representative that maybe will want to comment on this, but also for me as a member of the ACN Secretariat working on these issues, I found it interesting. The question was whether any country has the practice of monitoring self-cleaning measures in public procurement in line with Article 57 of the EU Procurement Directive. And this is important because this is something that has been raised in some of the WGB country evaluations, for example. And when we did recently the Anti-Corruption Integrity Review of Ukraine, there we were also examining Ukraine's system of debarment in public procurement in this context. The interesting thing here is that on the one hand, the standard established by a number of instruments, including the anti-bribery recommendation, is that countries must debar individuals and legal entities convicted for corruption from their public procurement. But at the same time, it's important to use this as both a disincentive for dishonest behavior and incentive for good behavior. So there should be a way out for companies. So on the one hand, there should be a debarment in place, but then the problem that we find in some countries is that often it's not clear how companies can have this. Either debarment is indefinite, it's not limited in time, or there is no clear way for companies to have this reversed. And so it may disincentivize self-reporting, first of all. And of course we want to give companies, even the companies that are somehow involved in corruption, to give them a way out, to make sure that they can, through some self-cleaning measures, they can eventually have this debarment reduced or reversed. So I was actually very glad to see this question asked, because this is something that we think a lot about and also discuss. If countries have any practice in this respect, we would be happy to hear, but if not, I just wanted to kind of respond to this online participant that this is indeed a question that is highlighted a lot in the work of the WGB, among other things. Do we have any more questions in the room? I see BRD, so Afonso.
Thank you. So my name is Afonso Nazare, and I'm a compliance officer as well at EBRD, and I had a question for Mr. Lukauskas as well.
Very interesting, the guidelines that you presented on today. My question is more on the applicability of the guidelines. So what kind of capacity building or training does your agency deliver to ensure businesses can implement the guidelines that you presented on today? Is there anything that you can say about numbers of trainings delivered or uptake?
Sorry, probably I can't provide information with numbers and how trainings, but of course we organize trainings, sessions, lectures time to time, and it depends on the request, basically.
Croatia.
Thank you for the floor. I'm Tomislav Matoc from the Sector for Prevention of Corruption in Ministry of Justice, Republic of Croatia. I want to thank all the experts for their presentation, and maybe I have questions for Ms. Dubois from French agency. It is actually a kind of sharing experience from Croatia, but also maybe she can elaborate more. It is regarding actually reports of the whistleblowers. We noticed that with the implementation that we face some difficulties with this confidential person that actually receives complaint, because it is easy to set up by law that companies have to appoint these persons, but when you put all this in practice, you see that there are some difficulties they can face. For example, they have to maintain the confidentiality of the person. They have to know how to secure, collect evidences, how to forward these reports to some other institution, agencies, and beside of that, they have their regular job. So I wanted to ask whether the agency provides some kind of education for these persons, how to handle all these cases, because they are not. You can appoint this person, but these persons cannot actually handle real cases when they appear in practice, and this can be a problem, especially for the smaller companies. Maybe for the bigger companies, it's not that much problem, but for the smaller companies can appear as a problem, especially regarding their regular jobs, because they are not appointed for this position as a full-time position. So I just wanted to ask whether there are some additional trainings and educations provided, because our experiences say that there is a need for that, especially in the private sector and the smaller company, and how to provide all this education and I would say some additional support for these persons that are actually supposed to receive all these reports and after that handle it. It's not that easy task as it appears at first sight. Okay, thanks.
Thank you very much for this question. I think it's a very interesting topic. First, I should say that the mandate of AFA actually focuses on controlling internally the presence of a mechanism to have alerts from whistleblowers actually feeding AFA. So we are only delivering support to companies to set up a framework internally that allows whistleblowers to have confidentiality. We verify that the way the information flows respects a chain of reporting to ethics officers, and that this can be done without prejudice to their career, as you mentioned, and that their advancement will be safeguarded. The only caveat is that in France, the whistleblower topic is not handled by AFA. It's handled by the Defender of the Rights. It's another entity, a separate agency, which is entitled to give the status of whistleblower, official status, to people who report on offences. So this is another entity, and then AFA is present within this umbrella Defender of the Right as a specialized entity on corruption. So we are not the ones really training whistleblowers or in responsibility to really ensure confidentiality. But it's a discussion that is, ongoing with the defender of the rights. We only focus on the actual internal mechanism within the company.
Thank you. I want to introduce another question that we received from an online participant, and this is a question to Irina. So the question was whether AMEPIP monitors the integrity plans of state-owned enterprises and proposes improvements to the plans, or in terms of the conduct or implementation.
As I mentioned during my presentation, AMEPIP works closely with the compliance officer nominated by the SOEs, and these officers actually have the monitoring task of the integrity plans.
Thank you. I'm looking around the room to see if we have any further questions. I don't see any nameplates raised. From the online, perhaps I will ask this. So it was a question for Domantas, whether these your work with and the guidelines you provide, whether they also cover anti-money laundering and anti-tax evasion practices of companies.
Basically, yes, there are links to the relevant information.
Thank you. And that one point that was raised by an online participant, the question was, but I think it's not really a question maybe to any particular speaker, but an important point that we should probably highlight. So the question was to what extent all these guidelines and mechanisms and everything that has been discussed, to what extent they apply, or to be more accurate, to what extent they engage small and medium enterprises. And this is something that we have come across very often in our work, in that authorities do their best to engage the private sector in their anti-corruption activities, and this is a challenge, of course, by itself, but then it often happens that when engagement happens, it tends to focus or prioritize large enterprises, and small and medium enterprises are not often sufficiently included or engaged in these activities. So this is something that we always emphasize in our communication with the countries, in our exchange, in our recommendation. It is the need to involve the business sector in general, of course, but specifically the small and medium enterprises, because they face some specific challenges that are specific to the size of a company in terms of dealing with the challenge of corruption, establishing anti-corruption safeguards. So engaging these companies, identifying their needs, identifying their challenges, and then including these in the policies is, of course, very important. I think we can. It is time also. We're nearing the end of the allocated time for this session. So I would like to thank everyone, especially our speakers, of course, but also the audience, those who joined us in person, those who joined us online. So again, as ACN, we live kind of in a place where two universes meet, the WGB universe and the ACN universe, and of course countries are now moving from one to another, but still, and so it is, I think, probably through this kind of discussions, among other things, that ACN lives up to this mission of being a bridge between the two. So thank you very much, and of course we continue our work on business integrity, and we hope to see you all engaged in our work. Thank you very much.
Thank you, Erkle. One general remark, when we're speaking about business, and it's almost usual about the money. And I still remember the time, maybe 10 and more years ago, where Lithuania was on path to join OECD, and we've started to make some reforms in state-owned enterprises. And the first of the sectors who were affected in this was energy sector and state-owned enterprises in energy sector. And if we compare key performance indicators, let's say these days, these companies are among the best performers in business integrity. And beside to that, they now are showing and are among top performers when we speak about financial results. So you can see correlation between independent boards, between another recommendation and implementation of this, and financial results with less state-owned companies in the country, but more effective of them. Thank you very much.